Hello, this is Samantha Shares. This episode covers NCUA's Enforcement Manual on Letters of Understanding and Agreement, also known as LUAs. The following is an audio version of that advisory and the press release. This podcast is educational and is not legal advice. We are sponsored by Credit Union Exam Solutions Incorporated, whose team has over 240 years of National Credit Union Administration experience. We assist our clients with NCUA so they save time and money. If you are worried about a recent, upcoming, or in process NCUA examination, reach out to learn how they can assist at marktrickle.com. Also check out our other podcast called With Flying Colors, where we provide tips on how to achieve success with NCUA. And now the Enforcement Manual on LUAs. What is a Letter of Understanding and Agreement? An LUA is a bilateral document signed by the credit union's board of directors and the regional director RD. The credit union agrees to take, or not take, a certain specified actions. RDs often issue LUAs when credit unions have not adequately responded to less severe measures, such as documents of resolution. NCUA also requires LUAs for newly chartered credit unions and for the granting of permanent special assistance. Delegation of Authority SUP 16 authorizes RDs to enter into LUAs with elected and appointed officials of FCUs and FISCUs. RDs discuss and negotiate publication with credit unions to prevent unfair surprises to credit unions and their officials. The RDs will address the issue of publication in every LUA between NCUA and a credit union by including one of the following three provisions. 2. 1. This LUA will not be published. 2. This LUA will be published. 3. The RD is reserving for a reasonable time HISHA right to publish this LUA. 3. 2 minor modifications and variations of the listed provisions that clearly communicate the same ideas are acceptable. 3. This third provision can also specify the period of time within which the RD will decide whether to publish the LUA or can correlate publication to a specified event or the failure of an event to occur. A. Required Letter of Understanding and Agreement Provisions. This section is redacted. B. Published Letter of Understanding and Agreement. The FCU Act Section 206 Zone A, 12 USC Section 18786 Zone A requires the NCUA board to publish and make available to the public any written agreement or other written statement for which a violation may be enforced by the board unless the board, in its discretion, determines that publication would be contrary to the public interest. LUAs must be published if violations are to be considered enforceable. The NCUA board may take administrative actions against credit unions or officials when they fail to meet terms of published LUAs. Violations of the terms of a published LUA alone are grounds for administrative action, and, although not required, the LUA should include language to that effect as stated above. NCUA may enforce a published LUA by bringing an enforcement action, such as a cease and desist order or civil money penalty, and proving noncompliance with the published LUA. These publication requirements apply to all LUAs, including those issued to newly chartered credit unions, as well as those issued in connection with special assistance. NCUA may take an enforcement action, even if the LUA is not published, if the credit union fails to comply with the terms of the LUA and the credit union's conduct constitutes a material safety and soundness violation or violation of law or regulation. While not required by the delegation, the region should provide the Office of General Counsel and E&I with a draft of an LUA considered for publication 2 business days prior to its delivery to the officials of the credit union for signature. C. Non-published Letters of Understanding and Agreement. Non-published LUAs are not enforceable. The mere violation of a non-published LUA is not grounds for a formal enforcement action, but may serve as the basis for developing grounds for a formal enforcement action if underlying safety and soundness concerns or violations of statutes or regulations exist. The FCU Act provides that NCUA may enforce the terms of an unpublished LUA if the NCUA board approves non-publication based upon a finding that publication would be contrary to the public interest. If the RD recommends to the NCUA board that an LUA not be published because publication would be contrary to the public interest, and the NCUA board issues this determination, the LUA will still be enforceable. TheRDs recommendation must clearly show why publication would be contrary to the public interest. The FCU Act requires a quarterly written report to Congress to summarize all non-published LUAs that are enforceable under this exception. This exception to publication should be used rarely and only when conditions justify a conclusion that non-publication is in the public interest. D. LUAs with federally insured state-chartered credit unions FISCUs. NCUA may independently or jointly with the SSAs issue an LUA to a FISCU. The requirement for publication applies if NCUA attempts to take action based on a violation of the terms of the LUA. Therefore, RDS will include one of the three publication provisions discussed above in all LUAs issued jointly with NCUA and SSAs. This concludes the NCUA's Enforcement Manual on LUAs. If your credit union could use assistance with your exam, reach out to Mark Treichel on LinkedIn or at marktreichel.com. This is Samantha Shares, and we thank you for listening.